number 84, Federal National Mortgage versus Jeanty. I'm gonna let them clear the room.
It's nothing personal.
We lost our audience.
Your audience is gone. Okay, counsel, whenever you're ready.
May I please reserve 2 minutes for rebuttal?
2 minutes.
Good afternoon, Your Honors, and may it please the Court. My name is Adam Swanson with McCarter & English, and I represent the appellant Federal National Mortgage Association. To understand why Mr. Jeanty's acknowledgement and promise to pay the mortgage
What's the
debt...
purpose of the HAMP agreement? What's the purpose?
The purpose of the HAMP agreement is to see whether or not the lender will be able to accept payments, monthly payments, under the mortgage at an affordable level for the borrower.
So I'm sorry, we got the temporary eventually, perhaps, not in this case, the permanent, that's part of the problem. So what's being negotiated back and forth is the amount of the installments. It is not the actual total amount that has been agreed to as the debt. Am I understanding that correctly? That would not change, is that right?
Precisely. That's precisely it. And if you look at the HAMP program...
Well, is that right? Sorry, over here, because the monthly payments went up.
The monthly payments could go up, that's
But
correct.
they actually did in this case. I think the HAMP payments were greater than the mortgage payments had been.
That's right.
And does that represent accumulated unpaid interest that is then worked into the HAMP payments?
Sometimes.
Well, I'm asking about this case.
All right, so in this case, I don't think it's in the record exactly what it was, but what I can say to Your Honor is that it could have represented escrow payments for real estate taxes that were recapitalized into the loan. To understand exactly what this represents...
Or an adjustment in the interest rate, or was it an adjustable mortgage?
My understanding is that, so to step back, under the HAMP program, HAMP followed what are called waterfalls. And the idea behind the HAMP program was to try and apply the waterfall to determine when you could reach a certain percentage of the borrower's income. It was set at 35%. So the first task in a HAMP program was to ascertain the borrower's income. Once that was ascertained, you then had to figure out what was 35% of the income so that you could make what would be an affordable payment. And once you came to that number, you then looked at the debt. You capitalized all of the arrears, interest, escrow payments, late fees were waived. And then you brought the percentage interest rate down to 2%. 2% was the baseline. And if you brought it all the way down to 2% and you still couldn't achieve that 35% affordability level, you then had to do other things with the loan. For example, the loan's maturity date could have been extended. The loan could have been recast over 40 years. Sometimes that happened. It all depended upon the specific circumstances of the mortgage. But the idea was to reach the number at which you could make it an affordable payment for this borrower. And if you could reach that number and do what was called a net present value test, and this evidence is not in the record, I don't know what it was here, but if that net present value test showed you that it was more economically beneficial...
So what is the effect of what happened here with the HAMP agreement?
So the effect of what happened here is that the HAMP, Mr. Jeanty did not qualify for a HAMP permanent modification, but he did sign the trial payment plan in an attempt to be evaluated for the HAMP modification program. And under the trial payment plan, as was just pointed out, there was no question about the full principal indebtedness. The borrower's primary obligation under the loan documents was to pay that full principal indebtedness.
But it says when they're signing onto the HAMP agreement, I can't pay. I can't pay my mortgage. I'm behind.
Right.
So how does that translate into an acknowledgement of the entire debt and a willingness to pay it?
That's correct. So what you have to do is when you look at a mortgage debt is a bundle of rights. And those rights, primary among the bundle is the obligation to pay the full principal indebtedness. That's the primary obligation. And a mortgage contract is an alternative contract because it allows the borrower various methods by which they could pay the full principal indebtedness. They could pay it in monthly installment payments, perhaps over 30 years. The borrower could pay the debt with liquid assets, perhaps refinance the property, or perhaps they have the cash. Or the borrower can pay the debt through the property. sell the property, or in a foreclosure proceeding where there's a judicial sale of the property. But common to all four of those threads, Your Honor, is the primary obligation to pay the debt. And that is what is important for the general obligations law analysis, because Mr. Jeanty
So then
never
if I'm
questioned.
understanding your position, you correct me if I'm wrong, is that the agreement is a recognition by the borrower that, yes, I owe all this money, but I can't pay at this level of installments. Perhaps we can negotiate a different payment scheme. Is that why it's still an acknowledgement of the debt? Because what they're trying to do is come to an agreement so that they can preserve their property interest?
That's right. That's exactly right. So when the 2008 foreclosure complaint was filed against Mr. Jeanty, the lender demanded immediate payment in full, the second way that the primary obligation could be satisfied. And Mr. Jeanty, through the trial payment plan, was attempting to recapture his ability to make those monthly payments and to discharge the very same obligation in this very same manner. And the third department recognized that in Grover, where it said, there is no new debt here. We're not talking about a new debt. It's the same debt. It's one primary obligation to pay that debt, and that's what's been acknowledged in the agreement. And the fourth department's case, Judge Troutman, you were on the panel and asked the question, was it signed? It was signed here. It was not there. In the Bradley versus New Penn Financial case, there was an unsigned agreement. Here, we have a signed agreement from Mr. Jeanty.
But not signed by the lender.
That's right. And the General Obligations Law 17105 only requires that it be signed by, quote, the party to be charged, which is the borrower here. So it does not matter that it's not signed by the lender. I'd also observe that we don't know if the agreement was ever signed by the lender or not. We just know that the agreement was put in the record in the court below, and nobody disputed that all the way until the Court of Appeals briefing.
Counsel, one of the things that strikes me is, in '08, predecessor accelerates the mortgage debt, right? Files a foreclosure action. In '09, HAMP is signed, right? But you've got a clear acceleration in '08. And then from '09 to at least 2014, the foot's still on the gas on the foreclosure motion, right? So you've never de-accelerated the loan in all of that time.
I would say that the foot's not still on the gas, Your Honor. If you look historically and look at cases like Albertina versus Rossborough, traditionally, the situation Your Honor described is exactly right. Borrower breaches, there's an acceleration, foreclosure, done in a year. But we have a new regime since the financial crisis. And what we do in this new regime that's come about since the financial crisis is search for foreclosure alternatives. We have an entire part in the judiciary.
That's in your control. It's in control of the debtor, right? You could discontinue the action and sign the HAMP agreement, right? You could send a letter saying, I'm de-accelerating my loan. They're not mutually exclusive.
We're in the process of attempting to find those foreclosure alternatives through the HAMP program, through
But it
other...
seems like you wanted to keep your options open, right? Or maybe this will work, but we still have a foreclosure action going.
Well, it's happening during the foreclosure process. In the 3408 settlement conferences in the court, it happens every day. So it's the foreclosure process generally that triggers the parties to come together and search for those foreclosure alternatives. And this
So
court,
it's still being accelerated because that process is moving forward.
the demand for payment in full is still there in the complaint. That's correct, Your Honor. So the borrower is trying to recapture the ability to make installment payments.
And until you de-accelerate, statute of limitations is going forward, correct?
Until you de-accelerate, well, the statute...
If you accelerate by demanding, by letter, or by suit, that accelerates the loan. It's all due, correct?
That's correct, Your Honor. At the moment of acceleration, the statute of limitations to foreclose the mortgage...
Are you revoking acceleration by this attempt to try and negotiate salvaging?
No, we're not revoking acceleration
Okay,
through the
okay.
TPP. It's not a de-acceleration. The TPP is a General Obligations Law 105, promise to pay the debt signed by the party to be charged.
Let's say that happens, forget the HAMP, hypothetical. Same facts on a foreclosure action is brought, and during the pendency of that foreclosure action, the debtor makes a payment and says, I want to pay, I'm making this payment. Does that stop the statute of limitations, even though you never de-accelerate and you keep going towards foreclosure?
I don't believe it stops the statute of limitations, but under Section 17-107, of the general obligations law, that would reset the statute of limitations, so it would be renewed. Because as Your Honor points out, it continues to run, so that payment that gets made, and when we look at 107, the interesting thing about
Wait,
107...
is what you said applicable if the payment is made before the statute of limitations has run on the accelerated debt or only after?
It's made at any time a payment is made. The constraint in the statute is only after which your claim has accrued. It's not where your claim has expired. But the payment would revive if it was after the statute had expired, and a payment would reset if the statute is still running.
in
That's your
order-
position, these payments in the HAMP agreement, the temporary payments fall within that's your argument?
That's right. and
That alternative argument on the part of
That's
the payment.
correct. Well,
But for revival to occur, it has to be accompanied by circumstances amounting to an absolute and unqualified acknowledgement of the debtor?
The statute 17107 of the general obligations law doesn't provide that. And what's interesting about
What about the
17107...
what about the common law?
It doesn't? The common law?
The common law talks about it, but it's not about mortgage foreclosure actions. When you look at the case law, you look at the various cases, the Lou Morris case, you look at Petito versus Patath, those were not about foreclosures. 17-107 is the only statute in the scheme, aside from 105, that specifically talks about mortgage foreclosures.
But weren't those cases talking about 107, Petito and Lou Morris?
They were talking about it kind of as a sidebar, Your Honor, because in Petito, what you had going on there was this very strange agreement where PNC was paid a sum of money in exchange for the transfer of its mortgage, I believe, to Petito's nominee, right? And what this court said was that the payment was on account of a completely different obligation. It wasn't on account of the mortgage debt. So where you have a payment that's on account of the mortgage debt, you've got to look at 17107 of the general statutes. And that 17107 says that it doesn't reset the statute only if it puts the burden on the borrower to disclaim the intention, if a written disclaimer of intention is provided. And the legislative history just tells us why this is. The legislative history says in almost all jurisdictions in the country, the payment is a sufficient acknowledgement to imply.
And you're
So
saying
let's say we
common law
disagree,
doesn't...
let's say we disagree with you. Okay. Is that going to encourage or discourage any particular type of action? Perhaps you'll do as Judge Garcia has suggested, you'll just send a letter to protect your position moving forward.
I'm not sure I understand.
I'm trying to understand whether or not a decision that is disfavorable to you, that is to affirm the decision below, would discourage entering these types of agreements, or you merely find, as I say, one way maybe, as Judge Garcia has recommended, to protect your position.
That's right, Your Honor, and a decision that would affirm...
This is meant to help both parties. You get your money, they keep their property, right?
That's absolutely right, and Your Honor points upon a give-and-take problem. We have this new regime where we're looking for foreclosure alternatives, and in the process, this new regime needs to have that give-and-take.
Could you get a toll under the federal regs, or could you get a toll in exchange for the HAMP signing? Could you toll the statute?
That certainly would be something that could be in the agreement, that's right. There's no reason it couldn't.
I see your time is up, but with the
No,
Chief
go ahead.
Judge's permission, let's assume we don't agree with you on the general obligations law and you're arguing angle discontinuance. What's the difference between the filing of the motion to discontinue and the grant?
So the difference, Your Honor, is when you look at the Engel case, what the court was focused on was the party's action, right? The party's action in revoking the acceleration. The court was not focused upon the effect of the actual discontinuance. I believe the question was asked about whether or not the Newman versus Newman authorities in Engel should be carried forward. And the response from the bench at oral argument was, I'm concerned that if we rely upon the Newman versus Newman authorities, what is the impact of saying that everything is nullified that ever happened in an action? So this court instead focused upon the act of revoking the election to accelerate. And the act is
And is
the
making a
motion.
motion for a discontinuance an affirmative act that decelerates?
That's right, it does everything that the filing of the stipulation in Engel did. The only thing was you had some judicial discretion that
But
needed
is
to
it
be exercised.
enough to simply make the motion when you're at, the courts are involved? You have the ability by letter to say, I deaccelerate. But when you involve the courts, isn't it more required than simply the making of the motion itself?
It only matters, only the court's decision granting it matters if the reason that Engel holds is because everything is nullified by the judicial action, whether by stipulation or motion. But this court focused on the intention of the party.
So if you made the motion and the court, for whatever reason, denied the motion, you'd still have your deceleration because your act of making the motion communicated your intent?
If the court denied the motion, you'd have a pending action, so you wouldn't need to revoke the statute.
I think the problem here is that, unlike the situation, like Judge Trautman was saying, where you serve a notice of discontinuance, that is entirely within your control. But you left, by making a motion, you left part of the question up to the court, which is certainly not your initiative, it's the court's.
Sure, there's some discretion with the court, and if we were to hold a rule that says it's only when it's actually effective, then we're actually looking at the Newman versus Newman case law for the proposition the discontinuance occurs because of the nullification.
Well, I'm not focusing on the effect of the order. What I'm saying is, as a statement of what your intent was through your actions, you said, I'm going to leave it to the court to decide. I'm not decelerating it. I'm going to wait for an order that comes that effectively decelerates it for me.
I don't think you're leaving it to the court's discretion. I think the CPLR constrains you to have to seek your deacceleration, your revocation in that manner.
You didn't have to make a motion, though.
Yes,
You
yes,
could have
yes, you
just
did.
discontinued,
If
couldn't
you
you?
had other parties appearing, the CPLR requires a motion be made. It can't be done just by notice.
And there's a difference between making the motion and serving also, right? Those could be done on two different times, and the party might not have notice until it's served.
That's correct. The CPLR,
So why shouldn't we make it service instead of, even if we accepted your argument, service instead of filing, the date of filing? I mean, don't you want the borrower to have notice?
well, if you look back at the law, the question is not whether the borrower has notice, and that goes back to Albertina versus Rossborough, where you can have an acceleration without the notice to the borrower. If you're delving into the intent and what the lender is trying to accomplish, it's the act of bringing that motion on through its service that
Thank you,
matters.
counsel.
Thank you, Your Honors.
Good afternoon, Your Honors. If it may please the court, Brian McCaffrey for the respondent. I have my notes, but I would like to jump right in, and I think a very crucial point is that the running of the statute of limitations and the acceleration is rather amorphous, isn't it? I mean, it's not something we can really put our finger on. It's triggered, in this case, as I think all the courts agree, by the commencement of the foreclosure action. So at that point, it starts running, and it's tick, 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 and it's going off, and it doesn't stop, and it has 6 years to run when it would expire. Now, in this case, with this trial HAMP agreement, my adversary wants to argue that by Jeanty's and Ms. Ingrid executing it, it somehow reset it. I won't use the word revived, because that would seem to be if the statute had expired. At that point, it hadn't. It was still early in the action, it was 2009. So he says it reset it. But by the very language of the trial, the agreement, it says this cannot be deemed as a deacceleration, and that the loan will continue to accelerate. So those two positions seem to be mutually exclusive. On one hand, the agreement
Well, but isn't
says
that
it's running, and the other
Counsel-
hand, the agreement says it was set back.
I'm sorry, but isn't his point with respect to that is that the signing of the HAMP agreement is acknowledgement of the debt? It's not the effect of the agreement itself. It's an acknowledgement under the general obligations law.
I think his stronger, I think what he really needs to prove to the court is that it reset or deaccelerated. But to answer that question, I disagree that it is, and first of all, it can't be just an acknowledgement.
Those are two different things, right? The deceleration and the resetting are two different things, right?
No, I would sort of say they're the same. I mean,
Well-
when I say reset, it would set it back to the beginning, but yeah, decelerate. In other words, it's no longer running. It's no longer accelerated. And the only thing you could, way to do that is to reinstate the
I
loan.
think they are two different things, right? If, let's say, 3 years has run out of the 6 years, and then there's a HAMP agreement, right? If we're saying it resets, that would mean starting at the date of the HAMP agreement, you've got a new 6 years, right? If we say it decelerates, it hasn't changed the 6-year statute of limitations, it simply has decelerated the debt. So the coupons, if another 4 years go by, let's say, the coupons that were due a long time ago, they're still subject to that original 6-year statute of limitations. There is a difference between saying reset and saying it's decelerating. no?
Deaccelerate, yes. I think
So
deaccelerating would
what
be
happened here? Nothing?
nothing. The agreement wasn't countersigned.
It
I understand my adversary's point that it's to the party to be charged, but by the essence of the agreement, it was, I'm making it's not a, the
Yeah, I guess I don't even look at this as an agreement so much as an offer. Is that an incorrect way to characterize it? You have to make 3 payments, and then they get to decide whether they want to accept this. That's the terms of you purchasing an offer, an option,
Absolutely,
essentially.
it's an offer.
And it's a one-way option. They can decline it for whatever reason they want. It's not in the record why they declined it. Counsel says it may actually have been signed, but we don't know that. We don't have a signed version of it. So I view it as you having paid 3 payments to see if they would accept your offer, and they declined your offer.
Well, it actually made, I don't know if it makes sense.
Well, I
but they
do want
made
to ask
7
you about
payments.
that. I do want to ask you about that, because then there's 4 gratuitous payments that are made outside of the terms of the offer. What do we make of that in terms of that either being sufficient legally to revive the debt or creating an issue of fact as to what the borrower's intent was in making those payments?
I don't think that you can, it's reasonable to think that, I can't say otherwise before Your Honors, that it would be, it's not, a reasonable person couldn't say that the Jeantys may have had an intent to recapture their ability, as my adversary put it, to, under the mortgage right to repay. But let's look at other factors. And this is what the court started off with when it asked Mr. Swanson, the payment, the old payments under the note were principal and interest. That was $2,452. Under the HAMP agreement, they are actually $2,553. So it seems to have gone up, but actually it went down because under the original note and mortgage agreement, it was principal, interest, taxes, and insurance.
But they know when they sign the HAMP agreement, going to Judge Wilson's point, when they're making especially these 4 additional payments, they know that if they don't get this deal, the offer isn't accepted, that those are going to go towards original mortgage payments, right?
Yes.
So why aren't they just at that point, they're making 4 payments, they're kind of with the understanding that those are going to be applied to the original amounts?
The Jeantys, my argument is they didn't know what was going to happen in the future. They didn't know whether the bank was going to countersign or not. In this case, they didn't, or at least we don't have a signed agreement. They don't, even in the HAMP agreement, it says the $2,553 might not be your final payment. This is an estimate. It could have went up, it could have went down. How
Well,
can they
what
make
they
an
didn't- what they
unequivocal
didn't know-
promise
what
without
they-
knowing what the
excuse
end
me.
result might be?
What they didn't know is whether or not they were going to get out of this foreclosure and be able to keep the property. That's what they didn't know. It strikes me what they do know when they enter this agreement is that they have a debt, they're recognizing the debt, and they're trying to negotiate a payment that allows them to, moving forward, continue to pay down that debt.
And I say that's a new agreement. And this court in Petito said, well, if you have a new agreement, then you're not, I'm not unequivocally, I'm not,
No, you don't.
they didn't
it's
say, here's your
not-
promissory note,
it's not
re-sign
a
it.
new
They said sign a new
It's not a
agreement.
new agreement in the sense that you don't have the terms, because they haven't decided what the amount is going to be, correct? But it is an acknowledgement of the debt, because what you're doing is paying towards that.
This court has ruled in Batavia that under 17101, a mere acknowledgement is not enough. I need an unequivocal promise to repay the entire future amount. One of the
But-
other
but
things.
you're
And
that-
isn't it-
agreeing-
But that's what I had asked him before, so you can tell me if I misunderstood. Are they not, excuse me?
Sorry.
Are they not still on the hook for the entire amount of the mortgage, or were they also negotiating a lower debt?
Negotiating a lower debt. One of the things that, and I don't think you did it on purpose, but under the waterfall, one of the things that could be is a principal reduction. I've got lots of HAMP modifications eventually, or other kinds of modifications for borrowers. where the Jeanty's borrowed $384,000, interest is accrued. We're going to make a deal, we're going to change it in a lot of ways. We're going to extend it 40 months, we're going to, if you make 12 consecutive payments, we'll reduce it by 10%. Now your debt is only, whatever it is, $250,000.
I know, but
So a lot of things could have
fundamentally,
changed in the future.
fundamentally, Counsel, aren't they agreeing when they signed the HEMP agreement to all the terms and obligations of the original loan documents? How do you get around that?
If what you're, Judge Singas, if you mean by that, the other agreements that go along with the mortgage agreement, continuing to occupy the property, continue to pay taxes, yes, but not as to the payments that have been made. They changed the payment in the HEMP agreement. They changed it to $2,500. It was $2,400. They said this is an estimate. We don't know. There could be a principal reduction. I don't think you can make an unequivocal promise if you don't know what you're going to get tomorrow.
But that's the point. You don't know what you're going to get, and in this case, they didn't get a modification. But they were on notice when they signed
That
the
might
HAMP
happen.
agreement. Yes, and not only that they might not get a modification, but if they didn't, they would be left with the original loan agreement. And
And
that's
in
why
fact-
payments were applied
And in
towards
fact,
it.
the extra payments were applied.
I can't ignore that happening, that fact, but I still believe that he did not re-execute his original promissory note. He was trying to enter into a new
When he
agreement,
signed-
negotiation.
When he signed the HAMP agreement, it said, I can't pay,
Yes.
and I'm in default.
So how am I agreeing to pay if I can't pay?
But when you're making those 4 extra payments, are you making them under the HAMP agreement? Because you only had to make 3 under that, right?
I guess he was continuing on in hopes that he was going to be given what he was promised.
That's what gives me
or
pause
offered.
here, is when you start out by saying, I guess that's why. And when I look at our case law, particularly Crowe v. Gleason, which suggests this is a question of fact, the borrower's intent and why the borrower made payments outside of the statute of limitations period, and whether that restarts reaffirms the debt and restarts it, is a question of fact. When you start your answer, I guess why, what occurs to me is, we can't be guessing. If the record isn't complete, then there's a factual issue.
Well, then I think what we have enough on the record is that the most we can see is that the borrower's intent was to renegotiate his loan.
Well, not at the point where where the HAMP offer has expired by its own terms, right? And there's 4 additional payments made well after that.
But the HAMP trial agreement changed the terms.
Only for those 3 first payments, no? And if it says if it's not accepted, if it's not signed and returned by a date certain, it's done. It's over.
But the 4 payments that he continued to make, totaling the 7, were also the $2,553. He didn't go back and say, well, then I'll pay what was originally due under the note.
That sounds like a fact question, doesn't it? Why?
Well, But it's
Why
a
make any
fact, not a
payments- why
question.
make
I
any
think, Your Honor,
payments
it's
at
a
all?
fact that that's what he did.
Yeah, and why do you do it?
I can't say.
I can't say either.
I mean, I don't have the machinations of the Jeanty's mind. I can't delve that deeply. I wouldn't,
But what's the fact to find? He's paying them knowing they're going towards the debt. It's a recognition of the debt, that he still owes this debt.
I cannot concede that point. I have to say that it is if it is an attempt to.
He wants to line the pockets of Fannie Mae gratuitously? I mean, no.
No, he wanted to get out of foreclosure, and he wanted to be
Okay.
reinstated, but since he never was reinstated, then I go back to my initial point. Then, the loan was never de-accelerated. Those things are not mutually exclusive. Those things tie hand in hand. If they reinstate him, say, you're no longer in foreclosure, you're back to your monthly payments, they're new, and you're now de-accelerated. That's what my adversary point has to make here, is that there was a de-acceleration. I can't see that he could convince this panel of that, considering that it was never reinstated and hence never de-accelerated. I think those two things are inseparable.
Thank you, counsel.
Thank you, Your Honor.
Counselor, I wish to clarify your argument. Is it that the payments alone, absent a disclaimer, restarted the statute of limitations, and the appellate division improperly considered whether the borrowers intended to pay the remainder of the debt?
That's yes, for purposes of 17-107 of the General Obligations Law. Subset 107 and 105 set out two wholly independent ways that a debt may be, the statute of limitations may be renewed. 105 speaks about a promise, right? 105 speaks about a promise, and this court just held in Batavia that 101 doesn't apply to mortgage
So there's a
debts.
question was asked about going back for a hearing on there being a question of fact. Is it irrelevant as to what the intent of the debtor is here?
I believe that to be true, and if you see on page 24 of our brief, we speak about the Law Revision Commission's reasonings when this was passed, and their reasonings, when I'll quote, "The effect of a part payment is, in almost all jurisdictions, recognized to be an acknowledgment of the existence of a larger debt from which a promise to pay the balance can be implied so as to remove it from the bar of the statute of limitations." So 17-107 has a unique feature. It then says, unless that payment's accompanied with a disclaimer by the borrower, and that wasn't true here. So we have the implied promise by the payment is sufficient. We need the disclaimer to not reset the statute of
Payments under
limitations.
the HAMP agreement, post-agreement, either, both? Which one are you focusing
I
on?
would say it applies to all 7 payments, but especially the extra 4 payments.
Cal, I'm sorry, I didn't mean to cut you off.
No, Your Honor, I'd rather have your question.
Good answer. I just have a question, maybe you can answer this, but the last payment is made, even the extended payments, in March 2010. Why do you discontinue the action 4 years later? You could have foreclosed.
I'm not certain of why it was discontinued, Your Honor, and I don't believe that information is in the record. I would only be speaking from conjecture, but in my experience, oftentimes, there may be some procedural defect, and therefore, the lender elects to discontinue an action as opposed to pursuing an appeal of an adverse decision if it
Is
proceeds.
it of any significance that the motion was made days before the statute of limitations was set to expire?
It's significant because it wasn't made after. It's significant for that reason. I don't know that I could impute that to the decision-making that undertook below, but it was done before the statute actually did expire. And that's what's most important.
What was done? It was filed, it was
Served, Your
served,
Honor.
it was decided, what was done?
It was not decided. Here I
It
have
was decided nominally after the statute of limitations ran, right?
That's correct. Okay, so it's record 258, record page 258, and my notes say that it was filed.
It was filed.
That's right.
And we don't know on this record about when it was served, right? That's not part of the record in this case,
I
or
don't
if
bel-
it was served.
I don't believe so. It's not part of the record. The affidavit of service, of course, would be court record.
Does Engel require that?
No, Engel, you just look at the action in revoking, the action of the holder of the option and their intent to revoke through their action, and that is the filing of the motion or its service.
Thank you, counsel.
Thank you, Your Honors.